Good morning, good afternoon, everyone. Today it's my pleasure to introduce the brand protection in China. So firstly, I'm going to introduce trademark basics in China. You will see what are the differences between Chinese and European trademark system. Following that, we will discuss how to register your trademark in China. And after that, a lot of people's concern about trademark registration will be discussed as well. And lastly, we will see what are the enforcement actions against trademark infringement. So in general, the Chinese trademark system is very similar with European one. There are a few differences, but not huge. Basically, they protect the same thing. It's your logo, your brand name, or even the short name of your company name. Whatever it's part of your strategy, branding strategy, you can consider to use trademark to protect it. Once you register your trademark, then you can enjoy the exclusive rights, and whoever copy your trademarks or sell the products bearing your trademarks, that it's trademark infringement. If you do not register your trademark in China, then you may find a lot of copycats or counterfeiting in China, and then you will realize you cannot do much about that. That's why it's important to register trademark in China. And there are three principles you need to know about trademark protection in China. First is registration. So if you do not register your trademark in China, then you are not fully protected. That means you cannot do anything when the others copy or register your trademarks without your consent, without paying much expense to the lawyers. However, if you have registration, that it's your right, and nobody else can infringe your right. Trademark is territorial rights. That means if you have European trademark, that doesn't mean you have trademark right in China. Making sure that you either have a Chinese trademark or your international trademark has been extended to China. And different from a lot of countries in China, it is first to file principle applying to trademark. That means whoever is the first person to file and register the trademark, they can claim they are the trademark owner. And in China, when you file the trademark, you are not required to provide intent to use or evidence of use. That's one of the reasons why there are so many bad-faith trademark registration in China, because the Chinese authority generally does not check whether or not your trademark has been used. And that's that is one point that the trademark owner, like you, all of you, to be aware that to protect and register your trademark in China as soon as possible, even before you come to China. And to understand better of the trademark, you must want to know how trademarks work in China, and how is the whole procedure, how is the whole life cycle of trademark look like. So the early stage is you creating the brand name, because for Chinese markets, you must have, you may, besides the Latin name, you also need to come up with the Chinese brand name. But it's not a must, but for certain industries like food and beverage, customers' products, or consumer products and cosmetics, it's better to have a Chinese brand name so that the customers can remember it and pronounce it as easy as possible. Otherwise, someone else might come up with a Chinese name for your brand. And when you decide as many candidates as possible and choose the one that can register as trademark at the end. And after that, how can I be sure that my trademark can be registered as trademark? My brand name can be registered as trademark. Then you need to do the trademark search. Trademark search can help you to identify any similar or identical prior trademarks in China. Considering that every year in China, there are 6-7 millions of trademarks filing. And more than 50% of the trademark application will encounter similar trademarks. That means it will not be a straightforward registration. You will have to wait for 1.5 years or even longer to get the registration if your trademark is similar with other trademarks. But trademark search can help you to identify it and give you enough time to rebrand your trademark in China. And trademark search also check if your mark can be registered. We will discuss about it in details later. And when the search results are clear, you can consider registering your trademark. So you can choose national or international routes. Both are available in China. And depending on which route you are going to choose, you will have to hire a trademark attorney or not. For national one, it is a must to hire a trademark attorney in China, or a trademark attorney in your home country who will appoint a trademark attorney in China to do that for you. For the international routes, it's not a must, but if you receive office or action, that means if your trademark is not able to register at the first place, then consider a trademark attorney. Generally, it will take 7 to 18 months to register your trademark. And when your trademark is registered, remember you can use our logo on your trademark. But when you use it, make sure that trademark is the one you register. In terms of fonts, color is not that strict here, but fonts has to be the trademark you register, especially if you decide your trademark from the beginning. And used on the goods that you register. You cannot saying like register on scarf and use that trademark on services. That's not a proper use. And in China, it's common that your trademark could be challenged by the other people. And in that case, if you have sufficient evidence of use, that will be very helpful for you to maintain your trademark. Or even in the case that when you try to challenge some other trademarks, that will be helpful for you to build out your case. So keep the evidence of use in China, probably one set, for instance, just an instant, at least one set of a contract payment and custom certificate for each year, showing case you have used your trademark in China. And also a trademark will be registered for 10 years once it's registered. It starts from the registered date, not the application date. And you are able to renew your trademarks after 10 years, and there is no limitation of times. So theoretically, you can keep it for 50, 60 years. Trademark is very important in the context of e-commerce. Why? Because in the e-commerce, I believe all of you are worried about the counterfeits and copycats and may want to take down those infringing links selling the counterfeits. And without the IPR certificates, which include the trademark certificates, it will be difficult to do that. Therefore, having trademark register in place, it's important to making sure in e-commerce you do not find a counterfeit and copycat. And we have another webinar about the e-commerce and how to file the complaint there. And if you are interested, you can say that, and we will send the webinar link to you. So in details, what kind of trademark certificates you need to prepare in the context of e-commerce? First, it's registration certificate. And be aware of that. If your trademark is registered via the international route, besides the registration certificate, you also need a Chinese certificate of registration certificate. Why? Because for international trademark, it's not automatically issued in Chinese. It will be in English or Spanish, whatever language you choose at the beginning. And the e-commerce, they will not read those foreign language certificates most of the time. Therefore, you need to apply with the Chinese authority, China National IP Administration, CNIPA, for the Chinese certificate of this certificate. And it will take you around 1 month, and you only expect to spend like €6 for that. You can either register it for yourself, but I will recommend you to have an IP expert to do that for you because of the communication with the CNIPA. It has to be done in Chinese. And if your trademark has been transferred or renewed, transfer certificate or renew certificate are required as well. And also some suggestion to avoid the counterfeits or copycats in the e-commerce platform is to regularly monitor the platforms. Here are some ideas of how to monitor, but this is not an exclusive list. Use your imagination or use your common sense to monitor and find the counterfeits or copycats. And in terms of the the trademark law updates, there has been a draft amendments since 2023. The current trademark law is 2019 version. However, this draft is not into force yet. So in practice, none of it has been applying. It's just for your understanding of what is the trend in Chinese trademark law. So the draft amendments put more efforts against the bad faith trademark registration. If you see 67 and 83, you can see that for the bad faith registration, the authority, in this case, it could be the CNIPA, they could order fines for the bad faith trademark registration. And if you bring the bad faith trademark registration to the court, civil litigation, and the court could order compensation to right owner from the bad faith trademark registrant. Besides that, the draft amendment also forbids repeated trademark applications. That means if you, again, for bad faith trademark registration, they could repeat filing application, and that may be not available anymore. But again, a lot of details we still need to see. And for opposition, currently opposition period is 3 months. That means when a trademark is published, anyone can file a petition to stop the registration within 3 months, but it's possible it will shorten to 2 months. And for e-commerce platform, the draft also makes sure that whenever there is a copy of the trademark, it could be concluded as trademark infringement. And I already mentioned that trademark search is very important before you decide to register your trademark in China, because it's good to know before you register. It could save you a lot of money from registering if you know that your trademark is not able to register from the beginning. In that case, it will give you enough time to rebrand for China market before you investing the marketing cost, marketing expense, or any kind of related expense. And what to search? First, it's to search whether or not there is similar identical trademark already existing. Second, it's to see whether or not the trademark include high-risk elements, including national flag, name of the country. It's possible to tell the Chinese authority that this is not the national flag in your trademark or the name of the country does not confuse the customers, and it's still possible to register those trademarks. But I have to tell you that the chance of registering those trademarks are becoming lower and lower these years, and the CNIPA and as well as the Chinese courts take a more strict approach for those trademarks. So for SMEs, if that means you have to wait for 3 to 5 years to get those trademark registered, would you still choose that approach? Probably not. So check if your trademark include national flag or name of your country. And also another high-risk element, including the adverse impacts. I would like to share a case I dealt with before. It's a very bizarre case, but it indeed happened before. So I used to deal with this trademark case. They sold the pet food So instead of coming out with normal or trademarks name in China, they come out with a naked pet food as their trademark name. And naked, in this case, it means purely trademark food, non-chemical addition. But in the eyes of the CNIPA, they think naked means nudity, that it's adverse impact. They didn't read it in the full context. Instead, they just take this word and interpret it as what the dictionary told them about what these words mean. What I want to tell you is for this kind of words, especially it's foreign language, not in Chinese, you have to be very careful when you put that into your trademark name in China. Because once your trademark has been concluded as adverse impact, you may not even be able to use that in China. I'm not saying registering. And also, if your trademark is misleading or include a descriptive elements, it's also not be able to register in China. And because in practice, it might be a little bit different from your knowledge. So always consult with an IP expert about whether or not your trademark includes high-risk elements. And maybe you can already guess that it's more and more common your trademarks could be refused based on the absolute ground. The absolute ground is whatever I list here. Those high-risk elements, that will be absolute grounds. It's more difficult to overcome the absolute grounds compared with the similar or identical prior trademarks. And if the search result is clear, you can consider to file your trademark. And national trademark or international trademark. For national routes, it's only protected in China, not other country. But for international routes, you can choose multiple countries, including China. And also, if you consider participate a trade fair recognized by the Chinese government, you can claim the trade fair priority rights. That means after you attend a trade fair in China, for instance, like China International Import-Export, within 6 months, you can file this trademark and still put your application date as the date you go to the trade fair, making sure you did not miss the deadline of 6 months. And the national routes include the cost of national routes include the official fees of 40 euros and the attorney fees. So in total, you are looking at more than 400 euros, depending on your trademark situation and whether or not your trademark will be refused. If so, you will expect to spend extra 1,000 euros later on. If you go to the court, then it will be more than 10,000 euros you pay for. Therefore, again, trademark research is very important. And for international routes, it will be 700 euros, more than that, just for the official fees. And it takes 7 to 12 months to register your national Chinese trademark in China. That's a straightforward one. If there's any requirements from the Chinese authority, then it will be more time, of course. And for international routes, because it will involve different organizations, it could take a little bit more time, more than 18 months. And again, the trademark attorney is required in national routes, but it's not necessary at the beginning for the international routes. Unless the trademark has been refused, then you decided to try the second chance with the Chinese authority by filing the review or appeal. Then in this case, you need a trademark attorney in China. And similar with European system, there are 45 classes in Chinese trademark system that classified all the goods and services. But a little bit different from the European system. There is subclass principle. What does subclass mean? That means each class, they will categorize into different subclass. For instance, like class 25, maybe a lot of you know that it's about clothing, shoes. So if in class 25, In the class 25, there is subclass only for scarf and another subclass only for shoes, because they are in different subclass. So according to Chinese law, they are different goods. Then you may find your trademarks. If you manufacture and sell scarf in China, you register on scarf. But you may find some similar trademarks in shoes. Theoretically, they can coexist without any problem. And coming out with the trademark name in Chinese, because it will be very useful and helpful for your branding strategy in China. And when you decided, choose the similar pronunciation with Chinese character, or choose the Chinese character reflect the meaning of your Latin trademark, and making sure it's easy for the customers to remember. That's the whole point of designing a trademark in Chinese. And just a few words about the trademark in Chinese. These days, there's a new examination trend in Chinese, in the CNIPA, Chinese Trademark Authority. So they will use the AI to translate the trademark not in Chinese into Chinese, and then find the similar trademarks in Chinese to refuse your Latin trademark. And the translation is based on the literal translation. That does bring some trouble to European companies. And our suggestion is to double check when you do the trademark searches, and including the trademark search into the Chinese trademark. And if budget allows you, try to register both trademarks, including your original trademark and the trademark in Chinese. And here we have a very successful case study about trademark protection when participating trade fair. So there is an Italian startup. They design swimming suits, and they decided to attend the CIIE, the one I just mentioned, because it's a great business opportunity for them, for exposure and for business strategy. However, before coming to China and attending the trade fair, they do not have any trademark protection in China. And I met them during the trade fair, and we discussed about the trademark strategy. So since this SME only needs a trademark protection in China, because they already have trademark in Italy and also Europe, they decided to choose the national route instead of the international one. And also decided to create a Chinese brand name for their products. Again, they are fashion company, and they want to have as many customers in China as possible. So a Chinese brand name will be very helpful for in terms of the brand strategy. And I also remind them they should keep the full control of the ownership of the trademark. So if any of their distributor or any partner offer their opportunities to register the trademark for them under the partner's name. Sometimes it happens, the partner will tell you, because I am the Chinese company, it's easier for me to register trademark under my name, and then I can transfer to you. In this case, please reconsider, and I will recommend you saying no to this offer, because the transfer procedure will be complicated, which we will discuss later. And also, a trademark search is necessary beforehand. And the result is very good. After 9 months, the SME was informed that all their trademarks, including the Latin and trademarks in Chinese, were registered in China. So from this case, we learned that you should have your trademark in place before coming to China. And if you are already in China at a trade fair, it's still not too late, and register your trademark as soon as possible. And conduct the trademark searches before registering. And it's good. It's always good to register your trademark in Chinese, because it helps more consumers to remember your brand name. And your trademark should be registered under your name. Lastly, trademark registration in China may not as easy as you think, so ask for advice from IP experts. And after you finished, before or after your trademark registration, you may still encounter bad faith registration. And from Helpdesk, we receive a lot of bad faith registration every now and then, especially for those SMEs who do not have trademark in China at all. So what are bad faith registration? It's not necessarily all the similar trademarks are bad faith registration, but bad faith registrations are always similar trademarks. And it's another signal is that the trademark registrant holds many trademarks, especially for the foreign language, because you will ask, like, they are a Chinese company, why do they need a foreign, the trademarks in English or trademarks in German in China if they do not do business with international companies? And usually those bad faith trademarks, they do not have any, it is not registered with the intent to use. The target of this trademark squatting is to take this trademark and probably sell back to the trademark owners at a high price. It's also quite common that the agents, trademark agents or distributors of the business register the trademark without the trademark owner's consent. Therefore, choosing the right agents and distributors are very important. And if you encounter bad faith registration, do not worry. You always have options. Always talk with the IP experts of your options. And there are some options for you to comply with the CNIPA, at least here. But all this information, it's more for like IP experts. I do not expect you as a business person to remember all the details. It's not necessary. But when someone comes to you and tell you you encounter bad faith registration, just keep in mind that you have some options. And when you talk with them, you know you have these three different options. That's the whole point of these slides. So those three options are opposition, non-use cancellation, and invalidation. Opposition meaning you use this procedure to stop the trademark from being registered. That means this trademark has not been registered yet. And non-use cancellation is used against a trademark that has not been used for 3 years, because trademark should be used, otherwise it shouldn't be existing. And invalidation is for the trademark which has been registered. However, it infringes others' rights, and then it should be invalidated from the very beginning. And for opposition, it's better for trademark owner to have prior trademarks right in China. Otherwise, the chance to win the opposition is quite low. And like I said, the bad faith trademark, it's not registered yet, and you have 3 months after the trademark's publishing to register to file an opposition. So the timing for opposition is very important. And if you have any bad faith evidence, for instance, you realize that bad faith trademark registrant has filed loads of trademarks in foreign language, and most of them are copied from other brands, then this evidence you should also collect it and file it. And you can expect to receive the decision within 10 to 12 months. The official fees is €65. And if you lose the opposition, then you can consider using invalidation. You have to hire a trademark attorney to do that for European companies. For non-use cancellation, you do not need to provide you do not need to have prior trademark protection in China, but making sure the bad faith registration has been registered for always 3 years. And it's not relevant to bad faith evidence, so you do not need to provide that. You expect to receive the decision within 9 to 12 months. Similar price, €65, just for the official fees, not including the attorney fees. And if you lose the non-use cancellation, you can always review it. And invalidation, it doesn't require you to have the prior trademark right in China, but it's better if you have one. That means you have a higher chance to win the case. And the trademark, bad faith trademark, should be registered within 5 years. And if it's over 5 years, that will require your trademarks. It's well known in China. For a lot of European companies, it's not possible. And also in invalidation case, bad faith evidence is very important. It takes a bit longer time and takes more cost to start the invalidation case. And if you lose, you have to appeal to the court. Then you go to the litigation procedure. Besides complaining with the CNIPA, there are still other actions that I have been asked by many SMEs. First is the trademark assignment. So some SMEs, they will ask me, can I just talk with the trademark registrant and pay for them? And they will transfer the trademark to me. It's an option, but don't do it yourself. Have an IP expert to handle that because it's not as easy as you think. Well, trademark assignment is not a private issue. You have to record with the CNIPA and publish it. So once involving the CNIPA, it could be tricky. And also the money you have to pay to the trademark squatter could be expensive. Have an IP expert to negotiate for you. They could lower the price significantly much than the first price. And significantly cheaper. Make sure you do a background search of the assigner. And because if you don't do it, there is a chance that the CNIPA will not allow the trademark assignment. We have another case, you will learn that. And another possible actions, maybe some of you already know that you can consider to sign coexistence agreements. That means you both trademarks agree to coexist with each other. It used to be possible until 2021. There was a new practice that the CNIPA did not accept the letter of consent anymore, and that practice continues until now. The courts could be flexible, but if you bring your case to the courts, that means you already accept to spend more than 10,000 euros. For SMEs, it's not ideal. So when you consider the coexistence agreements, keep in mind that China is very different from other countries. And you can also choose to rebrand in China. That it's the most common used strategy once there is bad faith registration. And unfortunately, rebranding means you have to change the label, packaging, and marketing materials in China. That could mean a lot of cost. But compared with going through the whole procedure with the Chinese authority, that could be even cheaper. To avoid the bad faith registration, again, I will recommend to register the trademark as soon as possible before coming to China. And another case study, it's about the trademark assignment. So this SME, they try to use the trademark assignment to get the trademark rights back. And the trademark squatter, they owed over 90 trademarks. The trademark squatter is a Chinese individual, by the way. And half of them are copied from foreign brands. So we can see this is a bad faith registration. And after signing an assignment agreement and pay to the company, the EU SME filed a request for assignment with the CNIPA. Unfortunately, the CNIPA requests the evidence of use, not only from the EU SME, but also from the trademark squatter. But as you can imagine, the trademark squatter doesn't have any of those evidence. Therefore, the CNIPA refused the assignment because there is not enough proof of use. And also they found out the bad faith of the assigner. So the trademark assignment didn't happen, and the SME has to still pay the price and never get the money back. So from this case, we learned that the trademark assignment may no longer be an ideal action to overcome the bad faith registration. And before the assignment, right owner should run a background search to see if the seller has bad faith. In this situation, consider other options, like what I already mentioned, opposition, unused cancellation, invalidation. And because use of evidence of use may be required, so we'll preserve those and register trademark in China as soon as possible. It's the most cost-efficient solution. If you have registered your trademark and everything goes well for now, and once you've been in China for many years, at some point you may realize someone copy your products and using your brands on the other goods you never consent on. Then you may have encountered trademark infringement. In this case, there are many options, enforcement options, like sending a C&D letter, a cease and desist letter, or again comply with the CNIPA, or call with other authority, or even go to the court. But going to the court is not the only option, because a lot of SMEs, they thought, if my trademark has been infringed in China, then I have to go to the court. It's not true. However, before considering all these options, you have to collect and preserve the evidence. Why is this so important? Because the form of the evidence in China is quite different from Europe. For instance, like you have to provide loads of evidence to making sure this is an infringement before the court. And you need to notarize those evidence, the written evidence or website evidence. Otherwise, they will be invalid to use in the court, or even in the mediation or arbitration, or even be refused by other Chinese authority. Therefore, contact an IP expert to collect and preserve those evidence. And I want to mention one option specifically. Here, the rate detention by authorities. Those authorities include, you may imagine, police, and also in China there is a specific authorities dealing with the counterfeits, copycat. Its name is Administration for Market Regulation. Besides that, customs can identify the counterfeits coming into China or leaving China, and they are very efficient if they know your brand very well. So if you need to leverage or consider contacting Chinese authority, keep in mind that it's efficient, but you still need to provide a very preliminary evidence, depending on which authorities you're going to talk to. And always bring an IP expert to deal with that. Some authorities would prefer to talk with the IP expert instead of the employees from the companies. I want to emphasize the customs, because a lot of European SMEs are not aware of China customs. They could be very useful. So like I mentioned, it identifies and stops the infringing goods from entering or leaving China, not like Europe. They only check the goods coming to Europe. A few steps you can do. First step is to record your trademark with the China customs, but making sure your trademark has been registered in China, yeah? And keep in mind that the customs can only record those goods trademark instead of services. And again, if your trademark is international trademark, having those Chinese certificates in place. And then after you register your trademark with China Customs, you can also add your exporters or manufacturers to the whitelist. If not, the customs may stop those shipments from your exporters or your manufacturers, because they don't know if they are infringer or not. And if that happens, it will delay the whole procedure of the whole shipment, and that will cause loss to you, and you do not want that happen. And one thing has been missed by a lot of European companies to trade the customs, because the customs deal with a lot of shipments and trademarks every day. So you should let them know your trademarks, your brand, and how to identify the counterfeits and what are the authentic goods, to train them to be familiar with your IP. But these IP experts are very experienced. They can go to different customs or those often used customs and trade them very well. And if unfortunately the customs detain your goods or fortunately infringing goods, they will inform you or the recorded agents. Usually it's the person who helped you to register your trademark with the China customs. And after they informed about the infringing goods, they only allows you to reply within very short time. Usually it's 3 working days. And you have to pay the guarantee, which is about the same value of those infringing goods. Because the customs will put these goods into their warehouse and that will spend the money. And as the right holder, you should pay for it for now. And later on, if everything is clear, like if it's indeed infringing goods, they will release it. They will detain those goods and they will pay you back the guarantee. Or if it's not infringing goods, if it's from your exporters or manufacturer, they will release those goods. Again, they will pay you the guarantee as well. And here we have a case who successfully registered with customs, and the customs actually helped them according to the updates. So these SMEs, they are in food and beverage industry, and they found counterfeits in Middle East, and based on very preliminary investments in Middle East, they realized those counterfeits has been produced in China and exported from China. And the SME wants to stop the Chinese manufacturers from infringing. So they contact us, and there are some options we offer to them. First, because they have trademark protected in China, but this is an international one, they should immediately apply for a certificate in Chinese and with the CNIPA. And they also need to contact the IP lawyer in China to collect the evidence of infringement before doing anything further. And however, after the evidence collection, the SMEs can decide what options they will choose. And they should also record their trademarks rights with the China customs, who will help them to identify counterfeits in the future. And the SMEs listened to our advice and decided to go with the certificates in Chinese first. Within a month, they received that with the support of an IP lawyer. The lawyer also helped them recording the trademark with the China customs. However, they decide not to collect the evidence because it's very expensive for them to do it now. So they decide to monitor the manufacturer and probably will start the evidence collection actions later. And recently they update me that the China customs actually stops infringing goods and inform them immediately. And they detain those infringing goods after the IP lawyers get involved. And from this case, it is advised to apply for a registration certificate in Chinese at a CNIPA for international trademark. And use the China customs wisely, and they will be very helpful to identify and stop the counterfeits. And evidence collection is important while time and consuming, so consult with the IP expert in China. And lastly, there are some takeaway messages. For trademark right in China, no registration means no protection in China. It's important to do trademark search before registration, and it's recommended to design a brand name in Chinese as part of your branding strategy. And if you encounter a bad-faith registration, you still have many choices. Contact with the IP experts. Before taking any enforcement action against infringement, collect and preserve the evidence. And consult the IP experts whenever you have questions, or contact us. And I can be reached out from this email address. Or if you want to discuss some urgent issue with me or generally discuss about IP strategy in China, you can always book a meeting with me. It's free of charge. And this meeting can be booked multiple times, so feel free to use our services.